Okay, today I'm about to do a video on, I'm gonna start doing some reviews of some videos because, I see a need to, and I think also it's gonna demonstrate the ridiculousness that there is such a thing as a sovereign citizen. However, the video I'm going to show, this is the first thing I don't want people to think. I respect anyone who has the courage to represent themselves in court. And you're going to have some failures when you first begin. However, I also believe that you should prepare as well as you can before you get to court. And I know some people, they try to attempt to do that. They try the best that they can. And this is going to be an example. I'm going to play a court case right now, and I'm going to try to narrate it. And it's just an example of why you should prepare and what they are putting on the internet and showing the rest of the world, okay, and how you look. And I want you, and it's no respect to the gentleman that's in, disrespect to the gentleman that's in this video. I respect you. At least you gave an effort. We all, our first time out, we're not going to be very successful. However, I'm going to take this opportunity to use this as a teaching a situation. Wasn't anything in particular. I just picked a video off the internet. It wasn't I'm picking on you or anything like that. I just found a video. I found a video of this guy. He just does reviews of videos and he mocks and makes fun of people. So I thought that I should be the counterbalance to that and look at these videos and do a very good review of them myself. So we're going to look at this video. Anyway, let's continue listening to this.
It had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308 signed, and then it was a return to sender, Judge.
All right, Mr.
So
Hurst.
we attempted to do discovery anyways.
Mr. Hurst, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that comes to me.
This is what we're going to do. One of the things she sent you were requests for admission.
I refuse to accept any mail that is sent to me. They just had a field day with that. I refuse to accept any mail that's sent to me. Do you see where I'm getting with this? You cannot come through looking. I think this is self-explanatory. All right, like I said earlier, there are 4 rules to the game. There isn't any money. There's a public and a private. They do not mix, and you have to be honorable in all your dealings. You have to be respectful to all the court officials. You cannot be disrespectful to anyone, not the attorneys, not the judges, not anyone. This is a game of honor and dishonor. And when you go in and start conducting yourself dishonorably, you are going to lose. On top of that, they're going to make you look like a fool. All right, so let's keep going.
If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
That is silence is acquiescence. All right. If you refuse to answer, okay, silence is acquiescence. When you don't answer, you agree. When you don't answer, you agree. You have to put in an answer. I'm going to urge everyone, if you're looking at this, I want you to read a document by Tom Schoft. He is a CPA. He wrote a book called The Banker's Secret Manual. It is a very good book. He has audited banks. He knows what he's talking about, and he has a lot of good discovery material and things in his documentation that are admission, court documents that you can enter into on the record if you don't know what you're doing. It's called The Banker's Secret Manual by Tom Schoft. Okay, if you're going to do this, know where to get good material from. This is obviously somebody he's listening to.
All right, here it is. I open written discovery in this matter. You have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admission under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
Your Honor,
You don't want to accept
I'm not even sure. I do not have any understanding of this is my debt or not. They just coming with these allegations. I'm trying to see and verify if it is. Then when they called me the first time, they should have sent out verified documents stating that the original.
Okay, he wants a verification of a debt. A verification of a debt is you're asking for something to be sworn to under penalty of perjury. For a debt to be valid, it must be verified. This comes in accordance with 15 U.S.C. 1692G, which is the Fair Debt Collection Practices Act, which is what you should invoke in a situation like this. The Fair Debt Collection Practices Act, 15 U.S.C. 1692G. Okay. And in your documentation and in your answer, you're going to demand that they verify on the record. And that means to present some sort of affidavit. The judge in this matter, he's going to bring that up about affidavits, but things have to be attested to under penalty of perjury. So that's what you're asking. You're asking a judge. I'll be more than happy, but you know they need to submit some sort of affidavit in support of their documentation attesting under penalty of perjury that they are a creditor. He's gonna his questions that he's gonna ask. He didn't ask for any of that. There is a case in Georgia called Igana versus HSBC. It is a very good case for people to read. Somebody says they are already in dishonor. They already in dishonor by deception of. See, this is that bullshit sovereign citizen shit right here. This guy, Wayne Brown. All right. See, these angry people. All right. So just pulling shit out their mind that we're in a court proceeding. We're in a court proceeding. So he's going to say they are already in dishonor by deception on claiming to be a judge in a constitutional venue. They never claimed to be in a constitutional venue because you haven't asked them. You ain't asked them what jurisdiction they're operating under. They never said that. They never said not one time we in a constitutional venue. And as a matter of fact, okay, Article 1 courts are operating under the Constitution because under Article 1, Section 8, Clause 9, they have the authority to create tribunals that are inferior to the Supreme Court. Did you read the Constitution for the United States of America? Do you know what an Article 1 court is versus an Article 3 court and the purpose that each of those courts serve before you go around talking about somebody's not doing something unconstitutional? See, I'm here to destroy all this sovereign citizen bullshit so we can get to real sovereignty and real rights. Because there's a lot of bullshit that I believe that plants have come into this space and that have put in people's minds, as well as the fact that a lot of ignorant motherfuckers are circulating, don't know what the fuck they're talking about.
Original creditor and who it was, and that I truly owe this debt.
Well, Your Honor, I just indicate that we did attach to those.
They already,
excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. She cut
I'm
me off.
you, Mr. Hurst. I'm not going to have this.
Your Honor, she cut me off. I'm not going to have this. Talking.
This is not a clown show.
Oh my goodness.
One at a time.
I can't finish my.
So you already lost because you're dishonoring the judge. I wasn't finished. You don't have any court etiquette. Objection, Your Honor, that's hearsay. We need some. This is what you say when they put in court documents. They said, well, Your Honor, we've already submitted court documents. Objection, Your Honor, hearsay. We need someone who can come in and testify to veracity and validity of the contents of the documents that counsel is attempting to proffer into evidence. And you are looking for sustained or overruled. If they do not say sustained or overruled, I don't care what he says. He can start having a conversation with you or whatever, but you're looking for a sustained or overruled for the record. If he does not do that, that's called an equivocal ruling. All right? At which point you say, I take exception to the honorable judge's refusal to rule on my objection. Would you please enter sustained or overruled into the record so I can preserve the error? Because now you're letting the judge know that you are planning to appeal. This is hearsay evidence. Learn how to form an objection.
You will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr.
Yes, sir.
Hurst?
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute
I don't
you.
even understand what's going on.
I'm muting Mr. Hurst, and I will let Ms. Strickard say what it is she wishes to say. Then I will unmute Mr. Hurst and allow Mr. Hurst to speak. Ms. Strickard, you were responding, Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in, all of those materials were in the packet that was rejected, Judge.
Objection, Your Honor, hearsay. We need someone who can testify to the veracity and validity of the contents of the documents she's attempting to put in evidence. That is counsel. She don't have firsthand knowledge of anything. The representatives from Credit One need to be in the courtroom. That's why you're going to form an objection. So then he can say, okay, well, I'm going to reschedule this, and you're going to bring your witnesses in the court, because the attorney, all the attorney has is firsthand witness of the fact that the attorney did an administrative process that they were hired, but they do not have firsthand knowledge of who signed the documents, who was there at the consummation of the contract. None of those things that the attorney has firsthand knowledge of. So that's what you're challenging. Where are the witnesses for Credit One, Your Honor? Why are they not in the courtroom? I don't understand any of this. That's not going to fly. When somebody asks you, when they have a copy of a document, they have statutory codes on the record that a copy of a document is admissible as evidence if you do not object to it. So even if they come in with copies of documents with your signature on it, that's admissible if you don't know how to object to it. You don't admit or deny your signature, because the burden of proof is on he who asserts, not he who denies. You don't have to prove anything for them. You don't have to make their case. If they ask you, is this your signature on this document? You tell them that looks like a very good forgery, to the best of my knowledge and belief. I request that the Honorable Judge direct the plaintiff to provide the original documentation, wet blue ink signatures, or someone with an affidavit from their corporation who can bind that corporation with firsthand knowledge of the fact, attesting to the fact that they have in their possession the original contract that I signed. Then and only then will I confirm if that's my signature on this document.
Well, let's let Mr. Hurst respond.
Okay, so the understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt. Yeah, I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refused the packet, because I don't know if they're trying to contract with me or not. I didn't know what it was, so I sent it back.
All right, let me explain it to you again. Whatever political views you have.
I had no understanding that they were sending me these things. They didn't even tell me that they was going to.
Okay, right here, this is where you check the judge, because the judge is already right here starting to suspect that this person is a sovereign citizen and started making a reference to political views. So I take exception to the fact that you've made some sort of presumption of my political stance in this matter. This is not a case about politics or anything about that matter. Okay, now, that is not germane to this case, my political views. His political views are not germane to this matter. But at the same time, he talking about he don't know what is going on. And you let them make their case. You talking too much, number one. All you need to do is object. Object to everything that they say. They don't have an affidavit. They don't have anybody there who can testify. They don't have anybody there who can take the stand. And once again, you're going to have to acquire good communication skills. If you're going to go into court, court is a gentleman's game. It's a gentleman's arena. Okay. You're going to learn you're going to have to communicate effectively. You're going to have to study your words so you'll be listened to, as it says in the Sirach. But once again, I'm not coming down on this man, because at least he is trying. He is trying. He's trying to assert his rights, and he's going to have some failures. Everybody has failures. I have failures, and I was good at what I was doing and still failed a lot of times. So don't let that discourage you. But at the same time, if you're going to go into court, then you got to know how to move in court. This situation doesn't call for any reservation of rights or anything. This is a third-party debt collector. They don't have any right to collect a debt. You don't have to do any of these things. This is some of the easiest stuff I used to do back in the day. You just get them to verify the debt. But you know why he doesn't know about verification? Because no one has ever taken the time to look up what a verification is. Somebody look up the definition of verification from Black's Law Dictionary. Could you please put it in the chat so everybody can see what does it mean to verify a debt, or what is a verification? Somebody look that word up.
Timmy, in the last court date, did they say, or did she say, we're going to send you something?
Sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery. And she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself. But what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that.
And that is a dishonor. You signed a contract, okay? You put your signature on something. All right, now, a lot of times they destroy these original contracts and they don't have in their possession, especially if they're third-party debt collectors. And like I said, once again, you're not there to make their case. They bought this debt on pennies on the dollar. They don't have any right to collect anything from you. However, if you don't answer, third-party debt collectors is a big business. 75% of them, they making money because 75% to 80% of people just don't answer. And they get summary judgments. They get summary judgments because people just don't answer. So you got to so the first time you get a dunning letter or a letter that says you have 30 days to reply, or it's going to be presumed that this debt is valid, you need to reply to that within 3 days. As soon as you get that correspondence, you send a certified mail with an affidavit of mailing, and you do some sort of verification of debt request pursuant to the Fair Debt Collection Practices Act of 15 U.S.C. 1692G. Primarily, what you're looking for is for someone from that company to provide you with an affidavit attesting under penalty of perjury that they are a creditor and that you are a debtor with an obligation to them. That's all you're looking for. Now, when you look in Tom Schaaf's The Banker's Secret Manual, he has a document in there that you not only send to them, but an affidavit that you send as a courtesy to the CEO or the CFO, allowing them an opportunity to sign the affidavit and send it back. If you are indeed a creditor of mine, then send this affidavit. Send me I can form a debt collection company. As a matter of fact, in my credit course, I talk about that. You need to get my credit course, and you're going to see that I just went live on SBC University right now. You can go in the courses section, and that course is available to you right now if you are a member of SBC University. And we have a lot of stuff on dealing with third-party debt collectors. I had some wicked people. I mean, you need to go in our archive section, and we have a lot of good videos on handling debt collectors, a lot of good court documents and things of that nature. This is a very easy matter to deal with. But his approach was all wrong. He's trying to use this UCC 1-308. I don't understand what is going. You don't need to do any of that. The burden of proof is on them. All right, and they can't prove shit. So that's all you do is like, Yana, I say, objection, Yana. That's hearsay. We need someone. There's just the attorney in there. You don't even need to let him speak. You don't need to let her speak. Every time she tried to say, objection, Your Honor, hearsay. Objection, Your Honor, hearsay. And your judge is going to say, okay, I'm going to continue this and to the next date or whatever date. And you need to bring your witnesses. The judge did to me. You need to bring your witness and you come in with whatever witnesses you got. They don't have any witnesses. And attorneys cannot testify. They don't have firsthand knowledge of anything.
I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules cut against you, then so be it.
I got a question. They are claiming that this debt belonged to me. Would they have to produce all the proof and verify that this debt belongs to me?
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she had to produce the proof that this debt belongs to me, right?
She has the burden of proof.
Okay. Thank you.
All right.
Judge,
Okay, he doesn't understand what proof is. You got what's called in admiralty full proof and half proof. What they are producing in court is called half proof because it's not attested to under penalty of perjury. However, it's hearsay evidence. However, hearsay evidence is admissible if you do not object to it. So you don't know how to form an objection. Everybody on this call has heard somebody say, objection, Your Honor, sustained, overruled. Learn how to make a record. You're not there to talk to the judge. You're there to make a record in case you need to appeal.
I'm sorry, Ms. Rickards?
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
Let's give him one more opportunity.
Oh, you want me to resend the packet, Judge?
I want you to resend the packet.
And the judge is giving him an opportunity. He sees that, hey, look, this guy, this is a good judge. He was a good judge. This judge, I didn't see, he wasn't an aggressive judge. He wasn't disrespectful. He was a good judge. He gave him another opportunity. I'm going to give him another opportunity. Let's see what happens.
And sir, let me urge you as strongly as I can. So receive and open the package. Because if you do not, the request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said?
Why would you come in the chat room and say you don't know what this is about, but if it's about debt, the company's supposed to discharge the debt? Why do y'all do this sovereign citizen bullshit? See, this is sovereign. Don't bring that sovereign citizen shit over here. Understand court rules. You need to understand. So you don't just come in and automatically say, well, they got to discharge. Why they need to? They don't have to discharge any. This is a third party debt collector. You don't even have to discharge a debt with a third party debt collector. I'm not discharging a debt with a third party debt collector. I don't owe them shit.
To you.
Yeah, I understand. I got a question. Should they have sent me something before they send me this package since the last court date?
Sir,
to verify that?
Sir, they're not required. If you think you need some information, you have the right to seek discovery too. But you can't tell them how to litigate their case.
Okay, now he keeps on harping on verification of debt, but he's not explaining to the court exactly what it is he's looking for. As I said, once again, objection, Your Honor. We need someone who can come in and testify under penalty of perjury or verify under penalty of perjury this debt. All right, that's what you're doing. You know, when you're objecting, that's what you're saying. Objection, this is hearsay. There's only 4 ways to introduce evidence. You need to have someone who could come in and take the stand, an affidavit, deposition, or notarized documentation. All of which can be cross-examined or objected to. Objection, Your Honor, hearsay. We need someone who can testify to the veracity and validity of the contents of the documents that counsel is attempting to proffer into evidence, and wait for a sustained or overruled. More times than not, the judge is going to sustain it, because an attorney cannot testify to anything because they don't have firsthand knowledge. The officers of Credit One are not there. That's just an attorney.
Okay, so she's going to send me a packet, and I'm going to send her back a packet as well, right?
No, you're going to do what you choose to do. She's going to send you again those requests for admissions.
Well, you said the
Don't interrupt me again. We had this conversation before, didn't we?
Sorry.
We had this conversation before.
Go ahead.
As a courtesy to you, she's going to send you the request for admissions one more time. You will either accept the package or you will not. You will answer and serve the request for admissions in accord with the Michigan court rules, or you will not. And then if you do not, then those things will be deemed to be conclusively admitted. If you choose to send written requests for discovery, you have a right to do that too.
Conclusively admitted, because silence is acquiescence. The judge is giving you right here a principle of law. If you don't answer, you admit. Stay in honor at all costs.
You can send written interrogatories, requests for production of documents, and requests for admissions. Same as her. All right, we are on the record. This is 21-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
And what is your name, sir?
Kevin Hurst.
Okay. All right.
I do hereby reserve all of my rights, waiving none, not to be compelled to perform under any contract or commercial agreement that I did not enter knowingly, voluntarily, or intentionally. I do not accept the liability of any compelled benefit or unrevealed contract or commercial agreement without prejudice.
Is there anything else you want to say, Mr. Hurst?
That's it.
Okay, now, have you read a mortgage contract? Do you know that they got things in there that state that you have taken the time to take this to an attorney and had it reviewed for an attorney, that you can't come in and say that you didn't enter into a contract knowingly? They got your signature on the document. Okay. That's why you have to address that signature. None of that is even relevant or germane to this right now. You've already given jurisdiction to the court because you've been participating in the matter. And they produced documentation with your signature on it. This is not the correct approach. This is not the correct approach for a situation like this.
All right. All right. Where are we on this file?
Judge, discovery's been completed. Motion for summary has been filed. We are looking for the court to assign a date.
Okay. Let's get you guys a date. Mr. Hurst, do you have the motion for summary disposition filed on behalf of the plaintiff?
It looks like this.
What's that?
It looks like this.
I'm asking
Yeah.
the person who received the motion for summary disposition filed by the plaintiff.
Do I have it?
Yes, sir.
Yes.
Okay. So let's set you a date for hearing and we'll move on. Does July 26th at 10 o'clock, does that work for everybody?
Yep.
Does he know what a summary disposition is? You know, there's no material issue of fact for the judge to adjudicate. If you haven't answered, and the answers he put in just going to confirm everything that they are saying. You haven't put in any objections. You haven't done anything. Let's move to summary judgment. And this attorney know who she dealing with. She know she got one. She knows she got one.
Yes, Your Honor.
Okay. July 26th at 10 o'clock, we will hear the plaintiff's motion for summary disposition. Sir, if you wish to file and serve an answer to that motion for summary disposition, you must do so within the terms provided in the Michigan court rules. We'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to file an answer, be sure to serve both the court and the counsel for the other.
Yes, Your Honor.
Okay.
He needs to file something like motion to deny summary disposition or something like that, and list some reasons why, using the Fair Debt Collection Practices Act. Something like that. Just stay with the Fair Debt Collection Practices Act. When you're dealing with third-party debt collectors, just stay right there. It's consumer protection laws were put in there for a reason. These people with these assignments of debt, they don't have any right to collect on the debt. They don't have firsthand knowledge of anything. This should be a very easy case to win, without doing any sovereign citizen shit whatsoever. You don't even need to go down that road with stuff like this. I never did. I never went down a sovereign citizen road when dealing with third-party debt collectors. Never. Not no all caps name, HJR 192, none of that. Pick and choose your battles.
July 26th at 10 o'clock, we will hear the plaintiff's motions for summary disposition. Sir, if you wish to file and serve an answer to that motion for summary disposition, you must do so within the terms provided in the Michigan Court Rules. We'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to file an answer, be sure to.
And I just see so much wrong stuff in the chat. The chat is just full of sovereign citizen ideology. Proof. He said, he in the wrong court. He should be in a federal court. Federal court deals with, he can choose, he can remove it to federal court if he wants to, but he doesn't have to be in federal court. You can remove it to federal court.
Serve both the court and the counsel for the other side. All right. The court has had an opportunity to review the pleadings here. I was particularly interested in the request for admissions that was served by the defendant. Request for admission number 3. Does the plaintiff admit and have proof that the allegations against the respondent are true and accurate, with all documentation being verified, signature and seals? These were admitted.
They were admitted. What are you talking about? They were admitted. But the thing is okay, did you have an affidavit with someone with firsthand knowledge? But you didn't specify that. You just said that they have proof. They provided you evidence. Now, you didn't contest the evidence. You kept just asking the same question. You didn't challenge anything that they put into the record.
Number 4, does plaintiff admit and or have proof that the statute of limitations has not expired to collect on his alleged debt?
I don't know what the fuck that was about. He just threw see, this is somebody listening to somebody tell them what to do. There's somebody listening to somebody, or they found a document on the internet, looked pretty good. Let me throw this on the wall, see if something sticks.
Plaintiff admitted that. Does the plaintiff admit number 6 and have proof that the respondent had a meeting of the minds with Credit One Bank pursuant to the contract agreement in respect to full disclosure? And that's.
Don't they got your signature on the document? What do you mean, were there meetings of the mind? You signed the document and you didn't challenge the signature or the document at all. You never challenged the contract. So what do you mean, was there a meeting of the minds?
Said contract contains no elements of fraud by Credit One Bank. Plaintiff admits that.
Okay, let me tell you something, Luke Cage. You say I'm very arrogant. Only a fool thinks he knows it all. I don't know it all, but I know what the fuck I'm talking about. And you don't know what the fuck you're talking about. All right, I'm not arrogant. And you get the fuck out of my motherfucking chat, all right? Because I'm here to eliminate this stupidity. Yes, I'm arrogant because I know what the fuck I'm talking about. And if you did, you'd have a channel trying to show people how to do the right thing. And you the damn fool. And shut up and be quiet and listen.
Number 7, does the plaintiff admit and have proof that Midland Credit Management purchased this contract from the original creditor and is now the new owner of the alleged contract and of the said debt that is owed. Plaintiff admitted that. So what we have is we have an admissions by our defendant of the validity of the contract, admission by a defendant that Midland creditor is a proper party plaintiff. And then we have...
He just admitted to everything through his questions. Them questions didn't do anything but to confirm what the plaintiff is saying. Because you don't know how to challenge the evidence.
Request for admission number 8, does plaintiff admit and have proof that Credit One Bank did loan their credit to respondent and that the respondent is only obligated to pay back in money to Midland Credit Management? Plaintiff admitted that too. I also note for the record that having reviewed the brief answer to plaintiff's motion for summary disposition, first of all, contrary to the court rule, is not supported by an affidavit. 2.116G4.
Listen to what the judge is going to educate all of y'all right now. And this also applied to the plaintiff, but he never formed an objection. Where's the affidavit on the plaintiff's side? But he didn't have any affidavit supporting anything. He has to put in affidavits too, under penalty of perjury.
Says that when a motion for summary disposition under C10 has been filed and served, the opposing party here would be the defendant, may not rely upon his pleadings, but must, by affidavit or as otherwise provided in this rule, demonstrate the existence of genuine issue of material fact. Again, I note for the record, no affidavit was submitted here. I think it's fair to say that the pleading filed by the defendant is somewhat obtuse. I quote, for example, from the third page, the agreed upon proof of claim does not serve in place of the original account, for it is a conditional acceptance and not the foundation of an action, and does not become an original demand and amount to an express promise to pay the actual sum stated.
Did anybody know what the fuck he just said? I listened to that. I don't know how many, I don't even understand what he's trying to say. This is what happens when you try to use language. You try to use this language that you hear everybody else saying instead of saying something in simple terms. This is very simple. Your Honor, objection. We need someone who can testify under penalty of perjury that the documents the counsel is attempting to proffer into evidence, okay, have been verified under penalty of perjury or whatever. That's it. That is the only thing you're looking for is an affidavit. You don't have to attest to anything. It's all hearsay. It's a presumption. And you cannot rebut a presumption with another presumption. You have to rebut a presumption with a fact.
In his first paragraph, the plaintiff, and I'm quoting again, plaintiff claims that the living soul utilizes and addressed in his answer.
Why are y'all in here talking about the Dodd-Frank Act? Stop in the chat room. Stop this stupidity. Dodd-Frank Act. What about the Dodd-Frank Act? Just stop all this stupid shit. It's simple. Debts have to be sworn to under penalty of perjury. 15 U.S.C. 1692G, Fair Debt Collection Practices Act, when you're dealing with third-party debt collectors. You don't need shit else. Oh, my God. Man, y'all see these damn sovereign citizens. I'm going to start calling y'all out. So I'm going to start. It's some sovereign citizen shit. It's some of that sovereign citizen shit. Luke Cage, he got all his feelings and shit. I gotta teach you I was 1,000 times smarter than you. So what the fuck?
when in fact the address that is used there indicates that the living soul does not live at this address, but is receiving mail there. So the defendant has failed to appear. He has failed to support his brief answer to plaintiff's motion for summary disposition by affidavit as required by the court rule. The court has had an opportunity to review the pleadings filed on behalf of the plaintiff in this matter, and I'm satisfied. There's no genuine issue of material fact in this matter. Summary disposition is granted in favor of the plaintiff. If you'd be kind enough to send me your judgment under the 7-day rule, I'd appreciate it. We are on the record calling 21170-598. Midland Credit.
All right. The judge, I mean, that was a good judge. It was a good judge. You know, a judge is an unbiased arbiter in a dispute between two opposing parties. He's not a party to the case. He's just there to referee the case. He's a referee. You have to make your case. The burden of proof is on he who asserts, not he who denies. You got to learn certain this is what I mean when I say about learning principles. All right, that is a principle of law that you have to understand. The judge tried to explain that to him several times. The burden of proof is on he who asserts, not he who denies. You're not there to make a case. They're there to make a case. They got to prove their case. And all evidence has to be attested to under penalty of perjury. All right, there has to be an affidavit. Somebody needs to take the stand. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God? A deposition. They take you in a private room, make you swear in, ask you a series of questions, interrogatories, things like that. All right? Where's your evidence? They get by on hearsay evidence. And because y'all worried about bullshit, the Dodd-Frank Act. You know, we in the wrong venue, in the wrong jurisdiction. You know, we need to remove this to federal. That's a whole bunch of bullshit. Sovereign citizen bullshit. It's a guy did a review on this video, got 100,000 views, and it's 100,000 people think that you sound like a goddamn fool. Now, how are we going to make any progress in this movement and with stuff like this getting on the internet? Because y'all the one, he went to somebody for help. I know he did. And one of you motherfuckers talking about the Dodd-Frank Act, removing it to federal court. He came across one of you motherfuckers, some more talking about, you know, this is overseas. This is beyond seas. And, you know, this debt should be discharged by the fact that there was not any money or anything in circulation, according to HJR1. You just all this old bullshit that you cannot substantiate with any verifiable evidence. If you have not audited a bank, you need to stay away from those arguments. If you don't have a CPA ready to come into court and to testify on the penalty of perjury that conducts audits on banks, then you need to stay away from that argument. You need to use a different strategy. If you don't know what a subpoena ducis tecum is, which is a subpoena for documentation, Luke Cage, pull your panties out your ass, man. Pull your panties out your ass. I know it's bothering your asshole and everything. Your panties are slipped up in your ass. Pull them out your ass, dog. All right. Must be your first time coming over here. This is not where you want to go and get into arguments and shit over here, okay? Anyway, that's my review of that case. I'm gonna start. This is my first time doing this, so I'm gonna do this more often. Do some reviews. I'm just gonna start pulling cases off the internet and reviewing them because they get 100,000, 200, and 300,000, you know, views and things. This guy's over there making fun of everything, just making you just look crazy. And they find the worst stuff that they can find. They find the way. Now, once again, this gentleman, he's attempting to do something. He's trying, and you know, he's trying to help himself. Okay, and which is fine. And I respect what he attempted to do. But you got to get good counsel, and you have to commit yourself to study, and you have to know what you're saying. There is a document. I'm going to give it to you. This is for everyone who's listening. It's called the Court Tricks and Traps. Court Tricks and Traps. Let me see if I can find this document. No, I'm gonna do it over here. Let me show y'all this document right here is only 4 pages long. But if you study this document, it will help you in almost any type of court situation that you find yourself in. It's amazing when I'm trying to do something, all the equipment starts tripping and everything, you know. Just to get this laptop, I had to reboot this laptop. Let me see what y'all talking about in the chat. Affidavit of Walker Todd, definitely a document you want to study. But the document you want to study is the Banker's Secret Manual by Tom Schaft. The Banker's Secret Manual. These are CPAs who have audited banks. Okay? You need expert witness when you're going to do things like this. You need expert witnesses. All right. It's called Court Tricks and Traps. This document right here will help you whenever it's going to give you some insight on how to form objections. This is what this document is all about. I'm going to read this document to you so that you can say that you've read it, because it's only 4 pages long. And I know a lot of people, I tell them to read things, they're not going to read it. So I know you might be in your truck listening to this, or, you know, or just laying in the bed and doing something like this. So I'm going to take the time to actually read this document for you, okay? Let me make sure I got everything. Okay, this is by a guy named Valiant Liberty. He's a very good researcher. He has some very good information. I love his information. So let's look at this real quick. All right. Okay. The rats have laid a minefield of tricks and traps for the unwary, uninitiated, and ignorant pro se litigant who dares trespass into the monopolized realm of Texas courts. Now, this is for Texas courts, but it applies for any court. Any court. Because it's based off principles that are universal, that apply in all courts. By skillful and manipulative use of the rules of court and judicial interpretation of the rules, the lawyers, with the complicity of the judges, are able to get their hearsay evidence entered into the record as facts and deprive the ignorant pro se of his evidence. When the other side can get whatever they want, including hearsay, admitted into the record as evidence, and the pro se cannot get anything in evidence, the outcome is going to be obvious. You can't win without evidence to prove your case. This does not seem to be fair or in the interest of justice, but fairness and justice have nothing to do with the operation of Texas courts, or any court for that matter. Like an attorney friend told me, it's not about truth, justice, and the American way, it's about what you can prove. The pro se litigant is expected and required to follow the rules. The pro se gets no slack in Texas courts. A party acting pro se must comply with substantive law and procedural rules. And then we get some case law. If one is ignorant of the rules and how the rats manipulate the rules, the rats will invariably strip you of your property, steal your children, throw you in prison, or all of the above. And the rats will have done nothing wrong in the eyes of the courts. You should have hired an attorney, they will say. However, the final outcome might well be the same if you had. Even if a litigant wins with the aid of an attorney, often the only difference in the final outcome is that the attorney, not the adverse party, ends up with all your money and property. In either instance, you will have been impoverished and reduced to a pauper by the Texas form of justice. You can win, but still be a loser. The following information and authority is found scattered throughout and is taken from O'Connor's Texas Rules, Civil Trials, 2001, published by Jones McClure Publishing Incorporated. Accepting the comments in brackets. This is the best rule book concerning Texas rules of court that the author has seen. It is filled with annotations and explanation of the rules and procedures for Texas courts that can be found in no other one place. If you want to play in Texas courts, you should have a copy. You should have a copy of the rules of courts for your jurisdiction. It may be ordered by calling 1-800-626-6667. They also publish a book containing forms for pleadings. I'm telling people always get forms and pleadings book. Stop trying to write motions yourself and learn how to get a forms and pleadings book out of the courthouse to learn how to write your documents, and stop trying to write them off the top of your head. It is imperative that the pleading be properly drafted, or else you will surely lose. This essay in no way is intended as legal advice. If you want legal advice, hire an attorney. If you know of a competent one that you can trust and afford, otherwise do your homework. How attorney statements become facts or evidence, and how to prevent it. The trial court has the discretion to admit or exclude evidence. The appellate court will reverse only on the abuse of discretion standard. Okay, so they got discretion of what they will allow and what they will not allow. If the trial court sustains the objection, it will not admit the evidence. The party who offered the evidence still has other options that it must exercise, or it waives the error. If the trial court overrules the objection, it will admit the evidence. The party whose objection was overruled still has other options that it must exercise, or it waives the error. An attorney's unsworn statements are not evidence. U.S. Government versus Marks. I say that all the time. There's an attorney, he has firsthand knowledge of anything. You have to have witnesses. That's why people have to bring witnesses to court to testify. However, on appeal, a lawyer's unsworn statement can be considered evidence unless the other side objected at the trial. Normally, an attorney's unsworn statement must be under oath to be considered as evidence. If a lawyer is presenting facts to the court, the other party should object and ask the lawyer to be sworn and subjected to cross-examination. Y'all can watch a video called True Grit. That court scene in True Grit, that's what that attorney did to him. That attorney started testifying. He said, objection, Your Honor. If counsel wishes to testify, have him take the stand and subject himself to cross-examination. They do it all the time, especially with pro se litigants, because they know you don't know how to object. If a lawyer is presenting facts to the court, the other party should object and ask the lawyer to be sworn and subjected to cross-examination. I just said that. Banda supra. When in doubt, a lawyer should always object to the fact statements of another lawyer. If the other party is unaware that the lawyer is testifying and does not object, the administration of the oath is waived. If he testifies and you don't say nothing, silence is acquiescence. Remember the principles. Silence is acquiescence. The burden of proof is on he who asserts, not he who denies. Where can you find this at? In the back of a Black's Law Dictionary. That's where you should be spending the majority of your time. I'll show it to you in a little while right after this. Especially if you knew. People always asking me where I start. Start with principles. So it is presumed that when an attorney is stating facts without being under oath and not subject to cross-examination, the statements are the facts unless objection is made. Anytime an attorney starts stating facts, it is most likely hearsay, unless the attorney has firsthand knowledge of the facts, and even then, the attorney must be under oath and subject to cross-examination, unless the other party fails to object. Almost every time an attorney opens his mouth, the opposing party should be objecting. And I've done this in court in his work. Every time I was on a foreclosure case, every time the attorney opened his mouth, I said, objection, on hearsay. Objection, on hearsay. Objection, on hearsay. And the attorney got frustrated with me, and the judge looked at him and said, he can do that. He said, I'm going to reschedule this, and y'all both bring in your witnesses. When the trial counsel foresees the possibility that he or she will testify on behalf of a party about a disputed fact issue, not attorney's fees, the lawyer should resolve doubts in favor of preserving the integrity of the evidence and decide against continued participation as trial counsel. A testifying lawyer may still engage in out-of-court matters relating to the case, including preparing and signing pleadings, planning strategy, and negotiating settlement. Okay, so when a lawyer starts testifying to hearsay facts, the pro se should be objecting and demanding he take the stand under oath, submit to cross-examination, and that he withdraw as trial counsel. And a lot of times y'all come into court, if you notice one thing there, that judge didn't swear nobody in that case. Everything he was saying was hearsay. That's another trick that they use on you. Come into court, you ain't sworn in. Everything you saying, you say, Your Honor, can I be sworn in? Because they'll do that purposely sometimes, not swear you in. You come in and just start talking. Nobody sworn in. Everything is hearsay. He has carte blanche to decide who he wants to win. He has the discretion, because we got two fools in court. Neither one have sworn in. There goes somebody talking about he could have wrote UCC 1308 to reserve his rights. He did do that. That don't have nothing to do with this. Reserve his rights for what? Reserve his rights for what? Explain to everybody in the chat while I'm reading this why he needs to reserve his rights in this particular matter. Dealing with a third-party debt collector. A party should attempt to secure an explicit ruling admitting or excluding evidence, that is, a ruling on the record, either in open court or in writing, that specifically state the court's ruling, namely, that the objection is overruled or sustained. That's all you're looking for when you say objection, overruled or sustained. If you don't get that, it's equivocal. If the court does not make an explicit ruling but admits evidence over a specific objection, the court implicitly overruled the objection and the error is preserved. If the court does not rule, or if no ruling appears in the record, the error is waived. To preserve an error, objection must actually be overruled. If the trial court says that it will rule on the objection later, the statement is not a ruling and does not preserve the error. Hold on one second. Okay, I'm back. All right. So right here, what we're reading is that if you do not get an explicit ruling from the judge, okay, it's going to be implied that they admitted the evidence. You have to learn how to object, man. And I see too many people doing this. I see even people doing objections and they don't wait for the judge to say sustained or overruled. That Moore's in court, that video, them guys said objection about 30,000 times and he gets sustained or overruled not one time. So right here, if the trial court invites the party to re-urge the objection later, that is not a ruling. If the trial court responds to an objection by saying, okay, that is not a ruling. These types of rulings are called equivocal rulings, and any ruling on an objection to evidence that is not overruled or sustained is an equivocal ruling that does not preserve the error. There are 1,000 ways a judge can equivocate, and the pro se must be alert to these equivocations at all times and insist that the judge make a ruling. For instance, it might be stated, let the record reflect that an objection to the hearsay testimony of lawyer Shyster has been made, that the court has neglected or refused to rule on the objection, and I have objected to the court's neglect or refusal to rule. If the court equivocates or refuses to rule, the party must object to the court's refusal to rule and must make sure its request for a ruling and the refusal to rule appear in the reported record or in a bill of exceptions. I'm going to stop right here. I think I've said enough. That right there is enough. It's a 4-page document. I just wanted to put a bug in your ear of how to object to something. All right. This was an easy case. This is not a difficult. All this bullshit that y'all are seeing in the chat about reserving your rights, you don't use that on third-party debt collectors. You don't have to. A third-party debt collector is not entitled to collect the debt. Why would you do any of those bullshit things? When you know why you're doing all that? Because you don't know the law. You don't understand the principle of law, that the burden of proof is on he who asserts, not he who denies. You don't know how to keep your mouth shut. You don't have to prove anything. They can't prove it. They don't have nothing. This is not, cases like this do not in any kind of way require any kind of private sovereign citizen, no type of information whatsoever. Use the Fair Debt Collection Practices Act. This is some of the simplest stuff you can do. It's some of the simplest stuff you can do. Anyway, with that being said, that's it for today. I ain't gonna make these videos too long. I'll be back on another video, and we're gonna continue this on another date, and I'll have another video not too long after this. All right. Peace to the gods. Read this document once again. Let me recap. Let me show you this right here, the Banker's Secret Manual. This is the Banker's Secret Manual. You can see it right here. This is what you can use for situations like that. In the back of this manual, he has all the documentations that you need. Here's the affidavit for the bank I was talking about. The undersigned affiant being duly sworn on oath deposes and says that he or she is an officer at XYZ Bank that claims to hold the promissory note. This is what it said. Everything has to be attested to under penalty of perjury. The judge just told you that. That's your affidavit. You got to put in an affidavit like the judge just said, and they got to put in an affidavit. Neither of those things occurred in this particular matter. Okay. Notice of adequate assurance of due performance. All right, right there. Strategy notices. You know, you got suggested court admissions right here. Okay. These are things that you can use. These are professional documentation that you can use. Study this documentation and understand what its significance is and use it. This is the Banker's Secret Manual. Study the affidavit of Walker Todd. Study Court Tricks and Traps by Valiant Liberty. Those are the documents them are probably the only 3 documents you need to study if you're going to prepare for something like this. Anyway, peace to the gods. I'm out. I'll see y'all on the next stream. Peace.